Welcome, everyone. Good morning. I'm going to wait for some of you guys to tune in before I start my topic for today. Say hi. Let me know where you're tuning in from. I don't know what this filter is doing right now. Um, Good morning, Everbless. Good morning, YouTube, Instagram, Facebook. Thank you for tuning in. Happy new month. It's May already. The year is flying. Denzel says, you look lovely today. I like your lipstick. Thank you so much. I appreciate it. Hi, guys. Hi. If this is your first time joining in, definitely leave a comment in the box so I can say hi to you. Hi, Neil Bossy from Maryland. Um, for those of you who don't know me, my name is Aisha Chidole. I'm an immigration attorney, and I represent clients all over the United States with their family immigration matter. So your location is not a problem. We have offices in Florida and Atlanta. If you want to reach us, call us 407-995-6567. You can also send a WhatsApp 404-333-8751. Thank you, Nikki. Hey, D. Carter, long time. Um, Hi, Nikki. Okay. So today I want to talk. I got a special request to talk about parents. Parents are feeling neglected and left out, so I want to talk about parents today. And generally, like when I do this lives, if you guys have questions or things that you might want me to talk about, you can comment them in the comment box. And I just go through them. If there's enough demand, then I will talk about those things. Nikki says, I'm a regular watcher of your show. Thank you so much. Sika, this is your first time. Hey, welcome, welcome. Um, okay, so I want to talk about ways in which parents can get a green card here in the United States. And when I say parents, I'm really referring to parents whose children are over the age of 21. And I will talk about a path where they've entered with inspection and paths when they've not entered with inspection. So, first of all, what is entering with inspection? Entering with inspection essentially means that you entered into the country with inspection, meaning you had a visa and you entered into the country, and somebody in Customs and Border Patrol allows you into the country. And an entry without inspection is you basically cross the border, you came by boat, you came by land, but nobody, basically, allowed you into the country. So when you enter into the country with inspection, as a parent, one way for you to get your green card is your child has to be over the age of 21. And most importantly, your child has to be a US citizen. So if you have a child that's over 21 and a green card holder, that child cannot file for you. If you have a child who's married and their spouse is a US citizen, your daughter in law, your son in law cannot file for you. The person that files for you is the child, and that child has to be a US citizen. And if that is the case, you can actually stay in the United States and adjust your status, even if you overstayed your time, even if you've overstayed for 5 years here. If your child is over 21 and you entered with inspection, and you're not in removal proceedings, I'm just using an example, you can adjust your status with USCIS. So that is one way. Another way is, and I'm seeing all your questions. I'll get to all your questions once I just cover this topic real quick. And then another way is if your parent is outside of the United States, again, you have to be 21 and a US citizen, you can file for consular processing of an immigrant visa for your parent. And when your parent is approved, when your parent enters into the country, essentially that visa essentially converts to a green card. One thing I would tell you guys, for those of you that are petitioning for your parents, if your parents are anything like mine or like a lot of clients, parents that I meet, they never want to really technically stay here. They're like, well, I want a green card, but I don't want to stay here. Like, can I just live where I'm living and have the green card? One thing you have to communicate with your parents is that in order for them not to have abandoned their green card, they have to show that they've stayed in the US. They have to always be in the US for at least 6 months out of the year. One thing they can do is try and just bide their time, and then both their time, and then once they file for citizenship, then they can do what they want. But if they stay out of the country for like a year and then don't come back, there's a possibility that they could take their green card away from them and basically, say you've abandoned your residency. So if they're going to do it, especially those that are consular processing, meaning that they're not necessarily trying to move here, they have to know that they have to be here at least 2.5 years worth of time, of the 5 years before they become eligible for citizenship. Okay, so now I want to talk about ways in which, if you didn't enter with inspection, you can get your green card as a parent. I'm going to talk about two ways. So the first one is what we call military PIP, which means parole in place. And the second one is through VAWA. So let's talk about military PIP first of all. So if you entered into the country without, thank you so much, Sandra. That's so nice of you. um, if you entered into the country without inspection and you have, child in the military, usually there's something called parole in place, which basically will allow a U.S. military member to petition for either their parent, their spouse, or their children, even though they're undocumented and they entered into the country without inspection. The idea behind this rule is that, for a lot of people, they don't want people that are serving the U.S. Armed Forces, the U.S. military, to be dealing with the distraction. Obviously being in the military is a serious thing, and there's a lot of national security issues. So they don't want them to be dealing with stuff about deportation or removal or what's going to happen to my parent, or whatever it is. So that is a benefit to joining the military if you want to petition for your parents based on PIP, but your parents already have to be in the country for you to do that. Okay. And then finally, another way for parents to get their green card. This one, of course, is a sad way, but I have to give you all the different options. Is that if you are being subjected to emotional cruelty, psychological abuse, mental abuse, financial abuse, physical abuse by your U.S. citizen child, you can adjust your status, whether you entered with inspection or whether you didn't enter inspection, whether you're undocumented or whatever. I know for a lot of parents, this is a challenge for them, even though they're subjected to so much by their children, and because there's a lot of times where they feel that maybe they failed or they're a failure. But sometimes, as parents, parents do what it is that they can. Maybe some people cross the border and come here. Sorry guys, I have really bad allergies this week. Or that they cross the border to give their children a better life, but maybe things were not so easy for the child, and sometimes the child lashes out and takes that out on the parent and say, you shouldn't have brought us here, or you shouldn't have done this, even though to that parent, like, they felt like they were doing the best that they could to bring them here. But instead, the child, either demeans the parent, puts the parent down, tells the parent, makes fun of the parent's ability to maybe speak English or assimilate into the country, or like, oh, you've been in this country, for however many years, you still can't speak English, get your stuff together. Sometimes you have, children who want to get physical with their parents, or put their parents in apprehension that they're going to do that, or children who basically use psychological and emotional blackmail, when they're dealing with their parents, like kids, or if they're basically asking them to do what's right or whatever it is, and the child threatens that they're going to commit suicide or they're going to kill themselves. And for a lot of parents, that is an emotional baggage where you can't even feel like you can talk to your child, because you're like, if I say something, is the person going to go kill themselves, and am I going to be responsible? So obviously, there's a lot that goes into, cruelty from a parent to a child. So it's one of those things where if you feel like some of that is happening, maybe your child is skipping schools, your child is doing drugs, having issues with the law enforcement and how those things affect you. It's one of those things that, you can call our office and, we can evaluate to see that if you qualify for this. Like I always say, when you submit VAWA, VAWA is to protect you as a victim. It's not to punish or put your your child or your parent or your spouse in trouble. It's a benefit for you based on your spouse's behavior. USCIS cannot disclose that information to your spouse. Nothing is going to happen to your spouse. I mean, to your child in this scenario. So those are the three core ways for parents to adjust, to enter into the United States and become green card holders. So let me just run through them again. Through immediate relative adjustment of status. With that, even if you've overstayed, you don't need to leave the country. Second way is through consular processing, when your parent is outside of the United States and you're processing it for them. And then you have military PIP, which is parole in place, where even though you entered without inspection, you can still adjust your status and become a green card holder. And then, of course, the last way is through VAWA, which is if your child has been emotionally cruel or abusive to you. All right. Let me get into the questions and comments. I see a whole bunch. Let me start with Instagram first and see what we have here. Good morning. Good morning from Maryland. Beautiful from Massachusetts. Nikki, good morning. Hi, Colorado. Good morning. Okay. This person, Raleigh, says, what's the price of sending documents to get status adjustment to get a green card? Please call our office 407-995-6567, and then we can evaluate you for a consultation and then, decide whether you qualify or not, and then we'll go over all of that with you. Hey, Oyinye, how are you? Do I need a lawyer to remove conditions on my green card if my husband and I are still together? Yes. Of course you need a lawyer. I'm a lawyer. You can't ask me that question. You need a lawyer for everything that as it pertains to immigration. Now, it's a question, are some people able to do it without a lawyer? Yeah, but if you want your stuff done well, without any potential of any issues, you should get a lawyer. This is something that's important to you, right? Getting your green card, get your naturalization. These are things that change the trajectory of your life and the life of your family. So if you can have somebody who has knowledge and the ability to do it, why wouldn't you? Abhishek says, can I drive Uber without work authorization, but I have social security card? If I do it, is it going to be any problem for my paperwork? So I'm an officer of the law, so I cannot tell you to do something that is not legal. If the question is, do people do it? People do it. However, I cannot tell you to do it or not do it. That being said, if you ever work under the table or without work authorization, you should never, ever, ever, ever claim on any document or to any persons hiring you that you're a U.S. citizen. The minute you do that, you are barred from getting a green card forever, unless you qualify for like a T visa or something like that. So don't do it. Never write that on any documentation. I'm coming to you guys on YouTube and Facebook. Just let me get through some here. So D-Card says, if you have a VAWA case pending and you got a child during that period and you're not married, will that affect you? Will that affect the decision on your case in the near future? I mean, the answer to the question is that it depends. Are you saying that you had a child when you already submitted the VAWA application, or you had an extramarital affair during your marriage and you had a child? One thing about infidelity with the USCIS, it's really subjective to the officer and to naturalization. I believe in disclosing stuff. If you're a VAWA applicant and you and your spouse are no longer together, obviously things are not going well, and then you met somebody else and had a child, that should not affect you. Just make sure that you disclose that. The only thing that will affect you if you have a pending VAWA application is if you then go marrying that child. I mean, not that child, marrying the person who birthed the child for you. So, you cannot get married to somebody else while you have a pending VAWA case, because if you do, you've essentially abandoned your case. So, all right, guys. So my just give me a second. My phone fell off. So let's go back to a normal screen. I don't know why it's giving me all this silly looking filters. I don't want a filter. Okay. Everbless says, I have a friend and she's applied for VAWA, but her friend turned enemy plans on telling USCIS lies to mess her case up. Is that going to be a problem for her? She needs to be more private. Of course, she needs to be more private. When you say have friend turn into her enemy, I don't understand what you mean. It depends on what was sent. A lot of times, you as a victim, USCIS will generally believe you over somebody else unless, there's corroborating evidence of otherwise. So, it's really hard to be able to assess that. Heirs of Rome says, when is the closest date to have an appointment available? Honestly, I don't know off the top of my head. You can check out on our website, www.chidolelaw.com. And it should have availability. If I'm not available in the next couple of weeks, you can also meet with one of our other knowledgeable staff member at Trinchito as a calendar and schedule a consult as well. We all work together here as a team, so you're still getting me, you're still getting the team, but sometimes some people can't wait maybe a few weeks out, so she can also do the consult. All right, guys, I'm coughing so much, I might end this early. So T Miles says, can you please talk about a period of abuse for valid case? Does it matter if it happened while living together before marriage or during marriage? This is a very good question. This is a very good question. So abuse is your entire relationship. So abuse does not even need to be happening right now. You know, if abuse happened, years ago, and you just never got over it, and how it affected you, you can present that. And before February of this year, you used to the requirement even for cohabitation with your spouse was, in order to qualify for VOW, was that you had to live with your spouse after you got married. Now the requirement is anytime you've lived together, whether it was before marriage or after marriage, which essentially also means the abuse could have taken place before marriage, but it's just that you're married right now. So it's a combination of everything. Okay, guys, let me take some on Facebook. My mouse is dead, so I'm a bit slow. Sandra says, good morning. You look rested because you're glowing this morning. I want to say big up to your staff. They are caring just like you. Thank you so much. I will give them that feedback. Um, and then Bolanle Abudu says, I filed for VAWA since June 28th, but up till now, I have not received an EAD. What can I do, please? The answer will depend on, well, what year? Do you mean June 28th, 2021? That's one. Give clarification on that. The second thing is, did you file for an EAD the correct way? Because if you file for your EAD on the basis of VAWA, you're not going to get a work permit until your VAWA case is approved, which takes 2 years to 2.5 years. But if you file for EAD based on you being a family petitioner that's married to, because I'm not sure if I'm going to assume that you filed for VAWA based on spousal. If you filed in the correct category, you should definitely be doing an inquiry to find out the status, because if you did it in June, we're in May, so that's about 11 months, and just see what's going on with that. Okay. Good morning, Latoya. Good morning, Sonia Ife. Stephen Miller says, how are you? Why do you think that some people, when filing the I-130, also send in their marital evidence at the same time? Because you should be sending in your marital evidence. Your I-130 is what establishes that you have a legitimate marriage. So let me just break that down for you guys. Your I-130 is your petition for alien relative. Basically, if for no other reason, that is the most important application. If you're doing a standalone I-130, where you should prove that you're married, because essentially them approving your I-130 is basically them saying, we believe that you're married and that your marriage is legitimate. Your 485 is literally just checking for inadmissibility grounds. So, when the form says, have you ever been a prostitute? Have you ever conspired against the U.S.? Have you ever been in a militia group? All those things. Have you ever lied, misrepresented? So it's in that regard, it's really checking your application to see, are you admissible into the United States or are you inadmissible into the United States? But the actual form that requires all those bona fides is actually your I-130. The thing is, when you apply for a concurrent filing, like your I-130 and your 485, you don't know that that's what they're doing. So when they're asking you those questions, it's so that they can make a decision on your I-130 as well as your 485 on the same day. But if you file for an I-130 alone, you must submit all that evidence. Okay. All right, let's see. What time is it? Okay, still have a little bit of time. Yinka says, best lawyer ever. Keep up the great work. Tell them, let them know. Thank you so much. Livan says, good morning from Massachusetts. Hey, good morning, Minaj. Um, okay, so let me see what else I have here. Um, okay, I think I answered this one. I filed an I-751 petition without my spouse. I sent in a comprehensive application. I checked and saw that they took my fingerprints. What does this mean? And will I get my permanent green card soon? So taking your green card is a standard, not green card, taking your fingerprints is a standard practice for USCIS, okay? So no matter what application that you apply for, they will take your fingerprints. That's part of your biometrics because they have to make sure you're essentially who you say you are, and they have to see if there are any crimes or anything that basically they need to know about. So it doesn't mean anything because it's a requirement. Now, if you file for it separately, give or take, timeline wise, you're looking at 18 months to 24 months before a decision is made. However, there are always going to be people that they make decisions a little earlier and people that they make decisions a little later, but most people will fall within that window. All right, let's see what else we have here. Good morning. If your mother comes to America as a U.S. citizen and has never put her kids on her document and her kids are adults now, can she file for them? So the question or rather the answer to that will depend on what status were her children while they were under 18 when their mom became a U.S. citizen. So, if you were under 18 and you were a green card holder and your mom became a U.S. citizen, you have automatically derived citizenship from your parents. So you should be doing a different application because you're technically a citizen. You've just not formally done your certificate of citizenship application, right? But if your mother became a U.S. citizen and you were a green card and you were never a green card holder, and now you're an adult, meaning that you're over the age of 21, you will no longer be considered an immediate relative of your parent, and your only option is to do the family preference category, and that's going to depend on if you're married or unmarried. If you're married, you're looking at somewhere like about a 7-8 year timeline right now. I think the last time I checked last week, that's what I saw around 7 years. If you're married, you're looking at almost 14, 15 years timeline. This could change, because this changes every month from a family preference category. But if that's the case, you just kind of have to wait. And if you are in the waiting period, do note that if your parent files for you, you cannot stay in the United States and wait if you're an overstay, because you will not be eligible for your green card when it becomes eligible, because you cannot be in family preference category and have any single immigration violation, meaning you cannot overstay. If you do overstay and your parent files for you, and let's say the visa becomes current and now it's time for you to apply for a green card, you have to get a 601A waiver approved, and then you have to go back to your home country to finish it. However, in order for you to get a 601A waiver approved, you need a qualifying relative, which would be, of course, your spouse or your parent, and you would have to show hardship to them for you to be approved for that. Okay. Steven Miller says, thank you so much. You can really explain and make things so simple. Oh, thank you so much. Hi, Katie Ann from Utah. Thank you so much for tuning in. How's it going? Okay. So Everblast says, what if someone lies to USCIS about their kids and they have a green card and now want to apply for them? Can they still do it? No, I don't know if you guys, if ever blessed, maybe this is the first time you've heard me. This actually really upsets me, like when people lie about their kids. I don't know, maybe because I'm a mom and I have little kids, and I just can imagine. I try to come off from the place of judgment and not judge people based on how they do things. But please, for the love of God, guys, do not lie about your children. Most times putting your children on there is not a bar to you not getting your papers. Put your children on there, because when you lie about your children, and you get the status, you can go back and revert without risking them taking your own green card away from you, or you not being able to naturalize, or being placed in removal for misrepresentation, and them determining if the misrepresentation was material to you. So it is never worth it. Like I always say, you guys, I know it's very scary, when you're dealing with immigration, and, well, what are they going to think of me? What is this and what is this? But I always say, lead with the truth. Lead with the truth, because at the end of the day, these people are human beings. They're human beings just like you. Some people will lie because maybe they had an affair and stuff like that. But real people have affairs every day. Politicians are being taken down left, right, and center because they're having affairs every single day. So you're not a unicorn. Like, there's no moral, like, morally high compass, or like pedestal where, immigrants don't do the same thing as regular US citizens. So you're better off telling the truth. So, in your question, understanding the reason why those children were not included, would be helpful, because that determines how you can explain it to USCIS. But if you didn't include them, you can later on then try to file for them. That's gone. The window is gone, because if you do, then it will come to light that you lied, and then you as a green card holder will most likely get your green card taken away from you. Um, Everblast said, does USCIS look like they're moving quicker to you? Okay, so I'm gonna say this, but I'm gonna knock on wood as I say this. I will say this. In April, I have noticed that work permits are moving much quicker, much quicker. I'm knocking on wood, because I don't know if those particular people were lucky, or what it is, but I'm noticing that normally work permits had been taken about 5 to 9 months, but we're seeing people get it between 4 to 5 months, which is basically taking us back to pre-pandemic days, where it used to be a 4 to 6 month window. So I am hoping that this momentum continues, and that we continue that way. So in that regard, they're moving quicker. In other regards, no. In other decisions, no. And part of that is also because right now, USCIS is basically saying, we're not going to make or adjudicate work permits and travel permits at the same time, just to allow us to move quicker. So sometimes you might actually get a work permit that doesn't include a travel permit, and then the travel permit will come later, just so that they can move quicker and get people their work permits. So yeah. All right, this is the last question before I jump off. Let me see. What else we have here? Okay. I don't see any other questions. Oh, okay. I see one more questions. One more question. So Black Cute says, how much is your consultation fee? I need to call on a personal question. All right, call us and schedule. It's $150. We'll be happy to evaluate your case and see what you qualify for. I hope you guys have a great day. I will try to be on Friday. I don't think I have anything stopping me from being on. I'm usually on around 10 a.m. So you can hit the notification button on your Instagram and your Facebook, so you can be notified when I go on live. And then you can also hit the subscribe button on YouTube, so that you can be notified when I go live. And of course, share this video with your friends, your family, in your groups with immigrants and other people who need help, because they might find this information helpful. I hope you guys have a wonderful day, and I will talk to you guys on Friday. Bye.